Okay, we're going to get started. So I would like to introduce you to Ilya Shapiro. He is a senior fellow in constitutional studies at the Cato Institute and is the editor-in-chief of the Cato Supreme Court Review. He is to my immediate right. And then we have Professor Josh Blackman on the other side. He is a prolific author and professor who focuses on constitutional law, United States Supreme Court, and the intersection of law and technology, and he is a professor at Houston College of Law.
Would you like to say that here, or is that
We're going to say it just because you're here.
Until the trademark lawsuit finishes its way through the courts.
He's in trouble already. We're actually good friends. He's in trouble. All right, let's do this.
Well, thanks for having me back. It's good to be in Houston with my good friend Josh. It was an odd Supreme Court term last year. We pundits try to concoct some narrative every year about the term gone by, whether it was the triumph of minimalism or the court's turn to the left or to the right, or my personal favorite a few years ago was the court's libertarian moment. This trend spotting is mainly an artificial exercise based on the vagaries of the docket. It's not like the justices over their summer recess decide, okay, we're all going to adopt a different jurisprudential method this year, or we're all going to move left or right or something like that. But this year there actually was a phenomenon that overshadowed the court's work and put a metaphorical black ribbon on the term. I refer, of course, to Justice Scalia's passing. His midterm departure, he actually participated in more than half of the oral arguments, but his vote only ended up counting in about 16 cases, couldn't help but alter the course of history. His passing deflated the term in many ways, diffusing several high-profile cases, as we'll discuss, as well as removing one of the most quotable pens on earth from the news cycle the last couple of weeks of June when those big cases were coming down. He was a giant whose impact on legal theory and judicial practice can't be overstated, even if he wasn't able to move the law in his direction as much as he would have liked. But it turns out that his effect on this past term wasn't as big as what a lot of people might think. His vote wouldn't have changed all that many outcomes of the kind of biggest high-profile cases. I can really only point to one, Friedrichs versus California Teachers Association, which would have come out the other way had Scalia's vote counted. This was the case where 5 justices seemed poised to strike down mandatory agency fees, that is, payments of union dues by non-union members that are supposed to go towards collective bargaining. Anyway, that would have been a reversal of the lower court. Instead, it became a 4-4 affirmance. Another such 4-4 case was United States versus Texas, which Josh will talk about President Obama's executive action on immigration. But all that meant was that the lower court was affirmed without opinion. If Scalia had been voting, it would have been affirmed with opinion. So again, the practical result is the same. The other big cases similarly wouldn't have changed. Fisher versus UT Austin, staying on this Texas theme.
A lot of Texas cases.
The affirmative action case that I'll talk about in a moment. Scalia's vote there would have turned that into a 4-4 affirmance of the lower court without opinion instead of a 4-3 affirmance with opinion. So again, no practical change. The abortion case ended up being 5-3 against Texas, the Hellerstedt case. Again, with Scalia, that would have been 5-4, same result. And even Zubik versus Burwell, the Obamacare contraceptive mandate case, which Josh will also cover.
Texas also.
All right, we don't need the little snippets proto-heckling thing here. So anyway, instead of a kind of a unanimous facilitation of a compromise in favor of the challengers, that would have been a clean 5-4 win for the challengers. But again, practically speaking, pretty much the same result. And then the other cases were unanimous. Evanwell versus Abbott, the one-person, one-vote case that I'll describe, as well as the political corruption McDonnell versus United States case, also unanimous. And moreover, even if President Obama's nominee for Scalia's vacant seat, Merrick Garland of the D.C. Circuit, even if he had been confirmed in due course, he would not have been on the court in time to participate in these cases either. So again, even though Scalia's absence has affected the court and the nation greatly, especially for this coming term going forward about what cases they're going to grant, the term just passed, other than sort of the atmospheric difference, the change dynamic in oral argument, and the way that opinions are written, and the absence of his acerbic pen and things like this. But in terms of practical results, his absence had the least significance on the actual cases this term. And before turning those cases, just a few statistics for y'all to keep in mind, or to whip out at your next bar review, pub crawl, or what have you, to make yourself look really popular. Half of the cases this term had unanimous rulings. That's actually par for the course. That's not a function of it being an 8-member court. That's the norm over the last 5-10 years. There were actually 0 5-4 decisions. You hear about the very harshly split court. Well, none of the cases decided before Scalia's death ended up 5-4. You can pretty much count 4 cases as being 5-4 because they were really 5-3 or 4-3, but would have been 5-4 with the full complement of justices, I suppose. And even adding in the 4-4 cases, there were only 4 of those. It's a really low number of those strict splits this term. But there were a lot more cases with just 2 dissenting justices, 6-2 or 7-2. That's something new. You effectively had the court transformed into 3 blocks: the right, the left, and kind of the center pragmatists. So you had a lot of cases where, say, Sotomayor and Ginsburg would be dissenting together, or Alito and Thomas. Let's see. Kennedy had regained his crown as being on the winning side most often, 98% of the time, 81 of the 83 cases. That's not a surprise. And he was the only justice to be in the majority in all 4 of the cases that we can count as 5-4, the 4-3 or 5-3 ones that we can count that way. He was with the so-called liberals in 3 of them, and with the conservatives in the other one. Okay, enough of that. Let's turn to some actual cases. My first case is a Texas case. I think half the ones we're going to be talking about are Texas cases. Evanwell versus Abbott. 50 years ago, more than that now, 55 years ago, in the early 60s, the Supreme Court issued a series of rulings saying that the Constitution implied a one-person, one-vote principle. That is, that it's a violation of people's voting rights to say have one district that has 10 people and another district that has 100. Because that way, the district where there's only 10, each of those people's votes is 10 times as powerful as each of those votes that are in the more heavily populated district. These disparities arose over time because of industrialization and urbanization. So you had rural districts which had just as much power, just as many members of state legislatures as urban districts, even though the latter had many more people. And the court, in a series of rulings and different types of districting schemes, said that you have to roughly equalize voting power. But, and I've sort of elided this concept in describing this, over the decades since, there's been a shift in, whereas before, number of voters generally tracked total population, those 2 metrics started to diverge in various ways. In part because of immigration trends, in part because of differences in birth rates in rural, suburban, urban districts. And so you had a situation where even though total populations per state districts were roughly the same, you had great disparities in numbers of voters. However you want to define that, citizens of voting age or voter registration numbers or any metric of voters. And in this case specifically, this involves the Texas State Senate, where there are 31 districts, and at the extremes, the district with the highest percentage of voters had nearly twice the number of voters as the district with the fewest percentage of voters, even though they had the same total population. And so some of the voters in the former district, the district that has a high percentage of voters, sued Texas, saying that this violates one person, one vote. Because just like 50 years ago when we were talking about districts with different populations, here we have radical disparities in number of voters. My vote is worth about half of what that person's vote is in that other district. And there are actually three positions being litigated here, just like the lower courts essentially came out with different rulings. There was a split about this issue. Do you just defer to the states? Is it a political question that courts shouldn't be involved in anyway? Do you have to use total population? Is that the constitutional standard? These were all arguments that were made. And ultimately, there was a unanimous ruling. The entire court agreed with Texas's position, which is a rare occurrence, actually, this term at least. And they didn't say that you have to use total population. That's what the Constitution required. But they said that states could use that metric. And they left it up, they deferred to the states as to their judgment of what to use, as long as they're not violating an individual's right to vote under the Voting Rights Act and certain other things like that. Interestingly, 10 states around the country subtract certain populations from those total population metrics. Students or prisoners or non-resident aliens or the military residents. Some states do diverge from simply counting everyone for purposes of redistricting, and the court apparently said that that's okay, we'll defer. We'll have to see after the next census if some other state decides to use some metric of counting just voters, whether that's citizens of voting age, which is used in the American Community Survey by the Census Bureau, whether it's some other metric. We'll see if there's a challenge to that.
It doesn't have to be a state, but municipality, a city or town.
That's right, that's right.
To affect.
That's right. Anytime, generally you have new redistricting every 10 years with the new census, and so next time there's a new districting at any level, we could see whether the court really means that to defer all the way to the political choices there. All right, moving to still kind of a political case, but out of Texas and into the criminal law, McDonnell versus United States. Former governor of Virginia, Bob McDonnell, was convicted along with his wife Maureen of federal public corruption charges arising out of certain loans and gifts and other monetary goods that he got from a businessman in Virginia who was seeking to curry favor. He sold nutritional supplements and anyway wanted to get the governor's help in promoting his product and things like this. Ultimately gave McDonnell I think a ride in a Ferrari and paid for his daughter's wedding and a Rolex and all these. Looks kind of tawdry. I mean, like not kind of slimy, right? But you know, isn't this how politics is done? You know, your donors or your businessmen who throw parties for you, and then they get access. Isn't that, as Justice Breyer said during oral argument, are you asking us to criminalize all of politics? And the thing is, it's not like the businessman ended up getting some sort of earmark legislation or a regulation that benefits him or hurts his competitors, or a permit that he was applying for. There was no actual government act that inured to his benefit. What he got was access. The governor took his phone calls, would set up a meeting, that sort of thing. And ultimately, the court unanimously, in an opinion by Chief Justice Roberts, said that all of those things that he got access, that's not an official act. And to be convicted for public corruption, there has to be the quo for the supposed bribe has to be some sort of official act, which was lacking here. And a few weeks ago, the Justice Department decided that it would not re-prosecute Governor McDonnell under some more novel theory. They could not establish, they thought that they couldn't establish.
He did not have a private email service, just to get another right.
Sticking within the criminal law, and also with kind of sleazy but perhaps not criminal activity, it's a case called Luis versus United States. If any of you are going into white-collar criminal defense, this is a very important case. A few years ago, there was a case argued by the same counsel, a friend of mine in Miami, one of the leading criminal defense lawyers there, named Howard Srebnick. His client wanted to use some of the funds that had been frozen on suspicion of healthcare fraud to pay him, to pay the counsel. And he argued, self-interestedly, I want my client to be able to pay me, so unfreeze those funds. But in that case, that was a case called Cayley. there was intermingling of funds that were allegedly the proceeds of criminal activity and so-called untainted funds, and the court said, no, this is no good. You can't just spend your money even if it's on your lawyer, and then the government can't recoup the proceeds of your criminal activity. Split decision, 6-3. It was kind of convoluted standards and so forth. This was a cleaner case, this Luis case. Again, a case of healthcare fraud, Medicare fraud. I guess this is something that Howard's become known for defending. But anyway, here there was clear that there were some assets that were absolutely, everyone agreed, untainted. And there were other assets that were arguably tainted proceeds of the fraud. But Ms. Luis wanted to use what everyone agreed were completely untainted assets, again, to pay her lawyer, not to buy things or just have unrestricted access to them, but to pay her lawyer. And the government said, well, no, we need to freeze those as well, because how would we otherwise satisfy any judgment against her? Maybe her tainted assets aren't enough. We need to freeze all of her assets. And the court ruled 5-3 tough. If this pretrial restraint of legitimate untainted assets, restraining them violates the Sixth Amendment, the right to counsel. And so here's the practice tip. When I talk to lawyers, this is what counts as continuing legal education credit for them. Here's the practice tip. If you have sleazy clients, make sure they segregate their money from that which has already been laundered to that which is still tainted. So very key practice point. All right, Fisher versus UT Austin, arguably the biggest case of the term, the affirmative action case, the use of racial preferences. UT Austin does their racial preferences in a way that's different from almost every university in the country. This is not a case simply where in their admissions process, if you're a certain type of minority, not Asian, they don't count. They're not, because they can achieve on their own apparently. But if you're black or Latino or certain other things, then you get an advantage. No, it's not as simple as that. That's a case that actually Harvard and UNC and some other schools are litigating right now in the lower courts. But here, 80% or more of UT Austin's class is admitted through what's called the top 10 program. It's actually now gotten down to the top 7, which I'm sure a lot of you went to high school in Texas. You're familiar. If you finish in the top certain percent of your public high school class, you're guaranteed admission. And most of the class at UT Austin, most of the freshman class, and a whole lot of diversity is achieved through that program. So here, for the other 15 or 20% of the class, UT Austin employs a holistic evaluative method into which race is a factor, and they argued that to achieve a true critical mass of the proper kind of minority students, we need to use racial preferences. Now, 3 years ago, when the court took up this case, it kind of punted. There was a 7-1 ruling, Justice Kagan recused, saying that the lower courts deferred too much to the educational administrators. They really need to look behind the veil and see if there was no other method of achieving a critical mass, see what was actually going on, see for yourself. You don't just defer to the educational administrators. Well, 3 years later, Justice Kennedy changed his mind about that. Effectively, and probably got tired of this case and issued a ruling that's sui generis. The Harvards and the UNCs and those defending their racial preferences are certainly going to point to this case, but because UT's program is so unique, this ultimate ruling that favored them, it affirmed the lower court's second rubber stamp of the educational administrators' decisions. It's written in a way that I'm not sure could be used for something more, other types of programs. And that's why even though I filed on the other side of this case, supporting the challenger, Abby Fisher, I'm more sanguine than a lot of critics about the future of this type of litigation. I mean, obviously, if the personnel in the Supreme Court changes, that's one thing, but I don't think this represents a fundamental shift, say, in Justice Kennedy's thinking. Josh?
My turn?
Yeah.
My turn. Thank you so much. It's a pleasure to be here at the, let me get this right, the University of Houston Law Center. I teach at the Houston College Law. We've gotten out of the way.
Wait, I'm confused.
He's always confused. Ilya and I are good friends. We've been doing this for years, and I appreciate we can bring our traveling roadshow down I-45. I'll be talking about 3 cases, all of which implicate Texas, the United States versus Texas immigration case, the Zubik v. Burwell contraceptive mandate case, as well as Holman's Health, which was an abortion case. And Everything's always bigger in Texas. Of the 69 cases last year, 5 involved the Lone Star State, and we seem to always be on the cutting edge of civil rights, usually on the losing side, but occasionally on the winning side. So let's start with immigration. Throughout the last 8 years or so, Congress has not moved any immigration legislation through the body. The first major bill was called the DREAM Act. The DREAM Act would provide a pathway to citizenship for the so-called Dreamers. These are minors who came to the United States, not legally. They stayed, they went to school, upstanding human beings, whatever. They had a bill, right? The bill would have given them a pathway to citizenship. This bill managed to pass the House of Representatives, but was killed in the Senate. It was actually a filibuster that killed it. Okay. So about 8 months after the DREAM Act was killed in the Senate, the president announced his first executive action immigration, known as DACA, D-A-C-A, Deferred Action for Childhood Arrivals. What is deferred action? And any of my former students don't know the spiel. Deferred action is simply saying, we will not deport you. We are not giving you citizenship. We are not changing status. We are putting you on the end of the line for removal. Oh, but by the way, we will also give you work authorization. This is what's known as a lawful presence, that you're not here legally, but you have this thing called lawful presence. That is, you can work, you can accrue Social Security, and get other benefits under federal government. Okay. This policy went into effect, and roughly 1.5 million of the Dreamers applied, and there was no meaningful challenge to this. Sheriff Joe Arpaio and a few others challenged it, but nothing big, and the courts more or less upheld this policy. Fast forward till 2014. The next big immigration bill, the so-called Gang of Eight bill, which killed Marco Rubio. The Gang of Eight bill would have given a form of amnesty to millions of aliens who are not here legally. Okay. This bill actually managed to pass the Senate thanks to this Gang of Eight compromise, went over to the House. The House, perhaps foreseeing the surge of views on immigration, decided not to bring the thing up for a vote. So the House never voted on it. That day, President Obama went to the Rose Garden and said, if Congress will not take action, I will. And after the election in November 2014, he announced the new policy known as DAPA, D-A-P-A, which stands for Deferred Action for Parents of Americans and Lawful Permanent Residents. DAPA doesn't have the same ring to it. Now, what was DAPA? If you had a child who was a U.S. citizen...
Was it DAPA leper?
DAPA leper. Where's a leper? Where's a DAPA leper? So if you were a citizen, so he can heck know what he wants. I don't mind. If you were a citizen, you'll wind up in jail maybe. There it is. If you were a parent, a U.S. citizen child, you would get this deferred action status, lawful presence, through your child. Okay. Traditionally, and this is contrary to the so-called anchor baby myth, if you come to the U.S. and have a baby, the child cannot petition for a green card until the child turns 21. This is why this anchor baby myth is simply wrong. This would say, okay, if you have a child under 21, you can basically stay here with this non-permanent status. Shortly after this was announced, then Attorney General Abbott filed a lawsuit challenging the legality of DAPA. Now, the first thing he's saying is, wait a minute, don't states have no role in immigration? How is there standing, or how are courts even supposed to hear this? So the state of Texas argued, and this was, I think, ingenious. There's some very smart lawyers there in Austin. They said, driver's license. I mean, driver's license. When you go to the DMV and you apply for a driver's license, the fee that you pay is not the complete amount. The state pays a certain amount. It's not a lot, it's like a couple bucks, but it's a certain amount the state pays. They have to do a background check, these other sorts of things. That amount is what gave them standing. They said because of this DAPA, all these new aliens will get lawful status. As a result, they'll be able to apply for driver's licenses. And then because of driver's license, we incur standing. It's a very ingenious argument. I don't think it applies in many other contexts, but I think the standing here is solid. In fact, in an interview recently, Justice Ginsburg ruled, how she thinks about this, said, yes, Texas probably has standing. She even hinted at that in an interview. She shouldn't have, but she did. So let's move on to the merits, right? What did Texas claim was the problem? Okay, this wasn't about license plates. That was just a way to get them into court. They made a couple primary claims. First, that this was administratively illegal. They said that this was such a great policy that it would have to go through what's called notice and comment rulemaking. You have to submit to the public first, get comments back, and see what people think. Okay, they skipped that step. Second, Texas argued that this is what's called substantively unreasonable, that the statute cannot support this, that the president does not have this level of discretion to defer the prosecutions of millions. We're talking about, I think, 4 or 5 million aliens. Okay, so that's a substantive unreasonableness. The third claim, which is what Ilya and I filed several briefs on, focuses on the clause of the Constitution you should all know well, the Take Care Clause. How many of you say the Take Care Clause of the Constitution? Okay, my students, you got to raise your hands. Okay, there we go. The take care clause, the president shall take care that the laws are faithfully executed. This is a provision that stretches from King George III, the benevolent dictator, right, who would randomly suspend laws he didn't like to enforce. Our president cannot do this. And Texas asserted, with Ilya and I filed briefs agreeing, that this is a suspension of the law, that the president was not faithfully executing the law, he was simply ignoring a law that Congress refused to repeal. So this case was filed in Brownsville, Texas, right on the border with Judge Hayden. I was actually in his courtroom about a month ago for a hearing, and he issued a nationwide injunction putting DAPA on hold. This was appealed to the Fifth Circuit, and by a divided vote, 2-1, the Fifth Circuit upheld the injunction, and they said that DAPA cannot go into effect. Then the Supreme Court grants cert. When the court granted cert, there were 5 justices.
9.
Well, let me finish my sentence. There were 5 justices who I think were prepared to invalidate, covering up, 5 justices were prepared to invalidate the policy. But by the time the case was argued, Justice Scalia had passed on. So what happened? It was argued, I think it was pretty close. The court issued a decision that was 4-4, only 8 words. Yes, Ilya?
I'm just impressed, these 4-4 decisions just affirmed by an equally divided court, and Josh has written copious words and pages, probably more than anyone else, about one of these one-sentence decisions. It's really quite impressive.
Yeah, I've written I wrote a 70-page article in the Harvard Law Review on a case that was 8 sentences long. So, I guess I'm like, what's it? Justice Willett says we're the world's tallest midget or something like that. Was that ableist? Oh, okay, I'll move on. Not going to be invited back next year. So the court affirmed 4-4. What's the effect of that? The effect of that is that the Fifth Circuit's injunction remains in place, and this goes back to the lower courts. This will come back up this year because the case hasn't resolved. Unless we make America great again, I guess, and President Trump would simply dismiss the policy. But in the event that the election goes to Hillary Clinton, this case will come back up.
And what if a Republican wins?
Oh, Lord help us. Or the sweet meteor of death will hit us, and in which case we'll all be far better off. That's SMOG 2016. The second case I'd like to talk about is the contraceptive mandate case. Now here, I forgot to plug my book. Catherine, actually, raise your hand. Catherine was my research assistant last semester at the then South Texas College of Law, and my new book is called...
I'm confused.
You're unconfused? The book was called Unraveled, Obamacare, Religious Liberty, and Executive Power. Go buy a copy. I think we'll be talking about it in the spring, so read in advance. This case involved a provision of the ACA that's commonly known as the contraceptive mandate. I'm going to give you guys a newsflash. The Affordable Care Act has no contraceptive mandate. Shocking, right? The ACA says that insurers shall provide for women...
It's just a prophylactic rule.
There it is. Grizzly Griswold, right? So the ACA says that for women, insurers shall provide, quote, preventive care. The statute does not define what preventive care is. The Obama administration said, preventive care, of course, that means a full range of birth control, everything from the morning after pill to the patch, the pill to the IUD. Okay. The first contraceptive case that came up was called Hobby Lobby against Burwell.
I wrote a book about that.
You did write a book, which I cite in my book in a footnote. So the Hobby Lobby case was, can you require a for-profit corporation that's religiously organized to pay for contraceptives they deem morally sinful? And this case, although it was 5-4, it wasn't entirely 5-4. The primary argument that you heard from TV was, oh my God, corporations can't have religious beliefs, they can't have anything. Okay, only 2 justices bought that, and I'll give you a very easy example of why. If you are a kosher butcher, and the state passes a law saying that kosher butcher shops, which are incorporated, cannot engage in the ritual kosher slaughter because animal cruelty laws. Could you really say that that kosher butcher couldn't challenge that in the First Amendment? Of course they could. Every church, synagogue, or mosque you belong to is a corporation. Trust me, they are. They're all incorporated. So this idea that when you assemble with the corporate form you lack, you lose your rights, has been insane. That's why the Citizens United case is the most overrated case ever. I digress. This case, though, split 5-4 on whether it actually burdens the corporation to provide these drugs. I mean, no one's forcing the Green family to pop a birth control pill, right? We're simply making them pay for others. And by a 5-4 decision, Justice Kennedy was on our side, I guess, this time, and Justice Kennedy said, well, we can't make them buy this birth control because there may be some other way of getting women this contraceptive that's less burdensome. Okay. That tees up the second case. After Hobby Lobby, the government released a number of accommodations, which said, okay, religious nonprofits like the Little Sisters of the Poor and East Texas Baptist University in Marshall, we're not going to make you pay for these birth controls. We'll simply use your policy to provide them. We will make the insurance company provide it, or the government will reimburse them. I don't want to get into complicated details, but someone else will pay for it. Little Sisters of the Poor and Order of Nuns said, no, that is not going to work.
Another practice point. Anytime you can, sign up Little Sisters of the Poor as your client. It makes for great optics.
Yes. And the perverse part is the Little Sisters aren't even bound. I'll get to that in a minute. So you have this poor order of nuns. I actually met a bunch of them. I was at a lunch after. Were you there? No, you were.
Yeah.
Yeah, you were there. We were at this lunch after the case was argued, and it's a room full of nuns. I felt like I was in a casting call for the Sound of Music. It was awesome. How do you solve a problem like Scalia, right? So, you hadn't heard them before.
That was good.
Yeah, I tried. So, it's actually a real song. Google it. How do you solve a problem like Scalia? The Capital Steps.
Is that from Above the Law Review?
No, Capital Steps.
Oh, really?
Yeah. Google it. It's good stuff. So anyway, it goes to the Supreme Court, and the nun said, wait a minute, even if we're not paying for birth control...
They said we'll have none of it.
That's a sign. We'll have none of it. Let them serve is what the sign said. And they said, if you make us use our plan, if you certify that our insurance plan is being used, you are hijacking our plan, they said. You are hijacking our plan. So what happened? Went to the Supreme Court. It was argued. I was sitting 5 feet away. Ilya moved for my admission to the bar that morning. It was pretty cool. I was sitting 5 feet away from the justices, and they seemed pretty divided.
I'm undefeated in motion practice.
Yeah. He admitted his wife and me to the Supreme Court bar. So the Chief Justice.
I did another one last week.
Ah, good for you. So you're 3 for 3. Trifecta. So what we have here is a case where the justices seem divided. What happened after that is very strange. They assigned some homework. They said to the parties, well, we can't really decide this case. It's really hard. Try something else, right? Can you give us some other way that we can maybe get these women birth control without burdening religion? And the party said, yeah, no, we can't. They said, maybe it's something we do to minimize the burden, but we're really far apart, right? The government says you have to use the same insurance card. The sister said, use a different insurance card. Go on the Obamacare exchange. Buy a contraceptive-only mandate policy, right? So then what happened next? Pissed me off very big time. The Supreme Court issued an order saying, guess what? The party said they agree on a settlement. Go figure it out, you guys. There was no settlement. It was a fiction. The justices basically said, look, we don't have 9 people. Come back later, we have 9.
I don't know. I disagree with that analysis.
Yeah?
Yeah, I think they're... I mean, the plaintiff said that... in the homework that they posed, as you describe it, there was this Breyer-esque hypothetical. If, such and such and such, would that satisfy your solution, kind of a proposed compromise? Something like this, they said. Would that satisfy you? And the plaintiff said, yes, that would satisfy us because that means we wouldn't actually have to pay it. We would just notify the government, and we don't object to objecting. We just, the government would take it. And the government had a brief that basically hemmed and hawed, at the end of which they kind of grudgingly said, well, yeah, that might be able to work. And on that basis, they...
Well, what's the such and such, right? That's the important part. The such and such was, are you using the same plan or a different plan? The such and such was, could you do it without the notification, right? What if the nuns didn't actually object to this? And the government said, yeah, they don't have to object, right? So here's how it works. Imagine the nuns tell their insurance company, we want a policy without birth control. Okay. The insurance company knows what's up. This is a religious objection. That way there's no certification that's been provided. But where they disagree, and this is the big one, is if it's ultimately given, is it on the same plan or a different plan? At that point, there's no agreement. They basically, the court papered over a massive fundamental divide. So this is now being remanded to, I think, 5 or 6 courts of appeals. And I don't see...
And the government's called for filings from interested groups about what they should do.
Yeah, which won't really matter. So so this will come back up to the court next year. And guess what, by the way? Merrick Garland has recused because he actually dissented from denial en banc in one of the D.C. Circuit cases. So we're still at 8. So this won't be decided anytime soon. Read my 3rd book, Undone, and when it comes out in a couple of years.
Unbelievable.
Undeniable. So the final case I'd like to talk about in our remaining time before we go to Q&A involves abortion. This is the Whole Woman's Health versus Hellerstedt case. You may recall this case arose from HB 2. This was a series of abortion laws that were made famous by Senator Wendy Davis's pink sneaker filibuster a couple of years ago when she was trying to run out the clock on legislative session. Well, that didn't work so well because the governor called a special session and passed HB 2 a couple days later. So there were 2 provisions of this law that were being challenged. The first was a requirement that physicians hold what are called admitting privileges to a nearby hospital. The thinking is if something goes wrong with the procedure, that doctor can personally bring the woman to the hospital and everything's admitted neatly. The second provision was what were called ambulatory surgical center standards, that an abortion clinic must meet the standards that a surgical center would. For example, if you notice, the name of this case was called Whole Woman's Health and not Planned Parenthood, or the Planned Parenthood on the other side of 45. They meet all these standards. They actually qualify for the
Planned Parenthood didn't get involved. They actually probably would have preferred for HB2 to be upheld because their competitors would then go out of business.
Sadly, that's correct. They were not involved. There are many perverse incentives that we'll talk about maybe another time. But what this would have done was taking a number of smaller clinics, like in El Paso and McAllen and some, the far-flung regions of Texas, and effectively said, unless you can move up to these standards, we will put you out of a business. You have to shut down. These laws were challenged and went up and down the court several times. The key precedent here is one Planned Parenthood versus Casey. Now, I don't care what you hear in a debate, Roe v. Wade is not good law. Politicians will say, I support Roe v. Wade. It's not good law. It's been good law in 25 years. Planned Parenthood versus Casey.
What he means is that's not the governing standard. It hasn't been overturned, but Planned Parenthood.
It has been overturned. The trimester thing's gone.
Casey overturned it?
Yeah.
No, it's not overturned. It was just adjusted.
They denied it.
No, the point is, the point is that Casey is the governing law over abortion.
Yes, but Casey overturned Roe. Roe in a trimester framework, that's only Roe.
I would not describe it as being overturned.
Yeah, they denied it, but they did. Okay, anyway, we'll disagree. See, even libertarians disagree on stuff. So the governing standard is indeed Planned Parenthood versus Casey, which asks whether a law imposes an undue burden on undue burden on a woman's access to an abortion. In this case, it was appealed to the Supreme Court, and again, even with or without Justice Ilya, it didn't look good for Texas. I thought Texas was probably going to lose. And in a decision by Justice Breyer for 5 justices, it was 5-3, the court held that the law was unconstitutional. Not just these 2 provisions, but the entirety of the law. Texas's primary justification is that, well, we need these laws to protect the health of the mother. And the majority said, well, that's not really true. You don't really need admitting privileges to protect women's health, and most of these procedures are not surgical. And if something happens, you can just call 911 and put them in an actual hospital. So the court more or less applied a skepticism of the state's proffered health rationales. I think this was actually an expansion of Casey and actually far more, it's not strict scrutiny, but it was a lot close to it. Justice Ginsburg concurred in her usual manner, and she said, quote, "It is beyond belief that HB2 would generally protect the health of a woman, and certain that the law would, quote, simply make it more difficult for them to obtain abortion." She said this was simply a way of making it more difficult to get abortion, much like most gun control laws, making it difficult to get guns, but not actually have public safety. I got that one in. Justice Thomas dissented, and he charged that the court has a habit of applying different rules to different constitutional rights, especially the putative right to abortion. CT would overturn Roe in its entirety. CT is Clarence Thomas. And he says that we apply this sort of heightened scrutiny for abortion, and no other right gets that scrutiny, Second Amendment as well. And this is probably the most significant pronouncement of abortion since Planned Parenthood. I will stop here, maybe give Ilya some more time to heckle, and then we'll turn to Q&A.
Yeah, before we turn to Q&A, I just want to mention kind of a broader perspective on the performance of the Justice Department under the Obama administration before the Supreme Court, because effectively we can close the books. There's still arguments going on this fall. There will be some opinions, not too many, before the next president's inaugurated in January, so we can kind of look at the statistics. This past term, the government won 13 cases and lost 14. That seems kind of mediocre. It seems surprising, especially given the recent liberal victories on abortion and affirmative action, not to mention past terms in the Obamacare cases. It seems odd. Why is the government doing so poorly? But it turns out that 48% win rate from last term was its 3rd best year that it's had. Overall, the Obama administration has a record of 79 and 96. Which is about a 45% win rate at the Supreme Court.
Is that like Navy's win rate, or? Oh, sorry, was that too soon? Oh man, sorry.
Well, I thought A&M had a good win, right?
No, they did.
Yeah, so. Anyway, so 45% win rate. That is down significantly from George W. Bush's 60% win rate. Clinton had 63%, George H.W. 70%, Reagan had about 75%. But this isn't simply a tale of kind of with each year or each presidency, they're less and less successful at the Supreme Court. Because Carter, for example, was worse than Reagan, and then it was kind of like Reagan was sort of a peak of sorts. But anyway, if you look back more than half a century, that's about as far as I asked my intern to calculate these things, kind of the modern post-war record of the Solicitor General's office. is comfortably over 60%. And again, the Obama administration is at 45, by far the worst. Now, this is not an exact science. There are some judgment calls to be made about who won and who lost in certain cases. Some cases aren't pure wins or losses because there's multiple issues going different ways. And in the last 20 years, the court has decided fewer cases each term than before, so they're less statistically significant than they were in the 60s or 70s. But still, giving Obama every benefit of that doubt, his score falls far short. Now, you could argue that the simple one-loss rate doesn't tell the whole story, because after all, Obama's lawyers have faced a majority of Republican nominees on the Supreme Court. But so did Clinton, and that didn't stop him from beating his Republican successor. But the news looks even worse if you look at purely unanimous losses. Okay? President Obama set a record 44 unanimous losses, including 10 last term. For comparison, Bush had 30 and Clinton had 31. And so Obama's lost unanimously, not a single vote even from his appointees, 50% more than his two immediate predecessors. And this is across all disparate areas of law, not just certain types of litigation. The government's arguments across this variety of cases would allow the executive branch to do effectively whatever it wants with little judicial restraint. Now, I'm not saying the government's lawyers are subpar. Solicitor General Verrilli and his predecessors, including Elena Kagan, are very well respected, and their staffs are filled with people who got better grades than I did and clerked for the Supreme Court. If these people aren't qualified to represent the government, then nobody is. No, this is a situation where, as noted Supreme Court advocate and commentator Miguel Estrada put it a few years ago, when you have a crazy client who makes you take crazy positions, you're going to lose some cases. And so the reason the president's done so poorly is that he sees so few limits on federal and especially prosecutorial authority, and assumes power to enact his agenda when Congress refuses to do so. The gridlock clause in the Constitution, which it's not in mine, but I don't know.
That's my thing.
Anyway,
I wrote that gridlock clause. That's my article. He uses my lines, but it doesn't work when I'm sitting next to him.
There was a footnote for what I said. You didn't see that? Anyway. So, all I'm saying is that if the next president wants to improve on the government's record, then I humbly suggest that he or she follow Cato's lead and advocate positions. We, by the way, beat the government. We had our worst year ever. We went 4-4, still beat the government. Taking executive actions and advocating positions that are actually grounded in law and that reinforce the Constitution's role in securing and protecting our liberties. Thanks.
It's a Q&A.
At this point, we're going to begin Q&A, but I understand that some of you may have 1 o'clock classes, so if you need to, you can depart and be on time for your classes. And if not, feel free to stay. We have Q&A, and we have time because this is not a classroom. But thank you all for coming. And we'd like to thank our speakers very much for gracing us with their knowledge and presence.
Any questions? Please be quiet as you leave, because I'm sure some people want to talk more, unless we were completely clear or obscure. Nobody cares anymore. You got your food, you got your comedy, you're done, right?
Oh no, there's some people staying. You're going to get some cues.
All right, raise your hands if you have questions.
You know, there's one.
Oh,
okay.
Yeah, I mean, you mentioned McDonald case as being representative, but that was tried under Virginia. The law was the Virginia law, which was much narrower.
No, it was federal law. That's why the DOJ was trying it. It's actually the latest in a series of cases where kind of broadly written federal law were either struck down or were convictions were reversed. There's the honest services fraud statute, the Skilling case a few years ago. There was another one, the Johnson case last year, where the residual clause was struck down because it was too broad and vague. And so this court, fairly unanimously in the last decade or so, has been pretty good at policing kind of catch-all legislation that tries to criminalize things that prosecutors kind of just have a general sense of them being bad.
I've heard from some professors of mine and things who deal with constitutional law that Citizens United isn't going anywhere. Personally, I dislike Citizens United greatly, but now Hillary's talking about trying to get rid of it. So what do you guys think? Do you think that that's possible at this point, or if it's too ingrained?
Well,
you go first.
Citizens United, all it does is says that people can get together and pool their money to speak about politics. So it should be much less controversial than it is. It has nothing to do with corporations giving to candidates. It has nothing to do with disclosures or dark money. It has nothing to do with foreigners. All of these things are completely unchanged. All it did was overturn an anomalous 20-year-old case that was the only one ever where the Supreme Court allowed a restriction on First Amendment rights for something other than preventing corruption. That was a leveling the playing field kind of decision. The Austin versus Michigan Chamber of Commerce. Anyway, it's hard to see Citizens United being overruled directly, but with a different, if Hillary Clinton appoints the next justice, then you could certainly see state regulations being ruled on or being upheld, even given the Citizens United standard. And so you could have a cabining of the case's practical effects for state laws. Now, for federal law, you can't bring a case to resurrect certain parts of McCain-Feingold that were struck down by Citizens United. So in that sense, that is never going to be reversed unless Congress passes a new law somehow, and then that's challenged. But that
we don't pass laws anymore.
Right, yeah, because of the gridlock clause. Yeah.
Right, so the short answer is to amend the Constitution, you need 2/3 of both houses of Congress, 2/3 of the states, and 3/4 of the states to ratify. To confirm a justice to overturn Citizens United, you need a majority of the Senate. That's why this amendment to the Citizens United thing is stupid. Hillary made clear she'll have a litmus test to appoint someone to Citizens United. I have no doubt that if state regulation tries to impose the same limits, it will be upheld. It's not long for this world. The curious thing about a litmus test, though, is a judge would basically tell the president, here's how I'll vote on a specific case. That ought to be automatic grounds for recusal, because they've already said how to vote in the case. But I don't think that's going to matter here. Yeah, the back.
What is Cato's position on the recent Saudi bill? Or either
JASTA? JASTA?
Yeah.
The
JASTA.
recent one that passed through the...
This was, I think, is that the first time that Obama's veto was overridden?
Yep, first time.
So this is legislation that would allow, or allows, because the veto has been overridden, so it's in law now, that allows lawsuits against, is it just Saudi Arabia or it's all national purveyors of terror?
I think it's Saudis, but I don't know.
Yeah, it might be specific. Anyway, and it passed, I think, with one person voting against it in the Senate. Harry Reid. But he might have voted against it for parliamentary reasons.
Yeah, for loyalty purposes.
Anyway, so pretty in Congress, an uncontroversial bill, and then with a veto override. I don't know if we've taken a position as a matter of policy. I know we haven't as a matter of law.
Okay.
I don't think it's unconstitutional.
Force of policy is
What's that?
Force of policy is, I suppose, is where I was aiming at.
Yeah.
I have to actually have a lecture on this in 2 weeks to try and start researching the question.
I mean, okay, well.
Yeah, I mean, so the short answer is this allows the United States to, this allows victims of terrorism, 9/11, to haul the Saudis to U.S. courts, right? Every action has an equal and opposite reaction. So I think what you're going to see is retaliation where foreign nations start dragging American citizens to their courts. And this is like, once again, you tariff, right? If you tariff China, China will slap tariffs on us. So it's a very difficult issue when you allow the suit.
But that's sort of been going on anyway, right? There was that renegade judge in Spain who issued who issued indictments for
Dick Cheney and
Rumsfeld.
Yeah, I mean, so you've had.
I'm sure Kissinger. There's a warrant out for his arrest in 30 countries around the world.
Yeah, that's why Bush won't leave the country because he'll be arrested somewhere. Yeah, so this is a diplomatic issue, but I can actually tie this to the Supreme Court. Remember the Zivotofsky case, right? Do we have to recognize Israel as a capital? Sorry, Jerusalem as a capital of Israel?